now. So hello, everybody. My name is Galia Aharoni-Schmidt. I am the founding attorney at Aharoni Business Law. We are based in Oakland, and what we do is help entrepreneurs build their businesses. So we do a lot of starting up, helping people choose their entity and form it for them. And we do a lot of contracts and with your clients and with your contractors and your employees. And we also do employment law. So we help kind of hopefully prevent lawsuits across the board and minimize your risk in every way. So, so this issue of independent contractors has come up a lot in the last few years in particular. And a lot of it's because of this case that we're going to be talking about. So the first thing I want to just jump into here, let's make sure my slides can change. All right, here we go. So question number one is, why do we care about this question? Why do we care whether somebody's a contractor or an employee? What is the big deal? So basically, and I want this to be interesting for both the companies working with contractors and the contractor themselves. And sometimes we are both. I'm a contractor to all of my clients, and I also have the option of working with contractors as well. So especially in this freelance economy, it's really important for everyone to know this. So if you're a business and you want to be working with contractors, you need to know whether under the law they're actually a contractor or actually an employee, because we want to be able to, so if you do get in trouble for this, we'll talk about the penalties in a second, but one of the things that's going to happen is it's really helpful to work with contractors because it's going to be cheaper for you, but you want to be able to avoid the penalties that come, including back taxes, penalties, lawsuits, all of that. And we've seen companies have to close because of the penalties that they've been hit with because of misclassification. So the stakes are pretty high if you're a client company working with contractors and if you end up getting in trouble for misclassification. So as a contractor, you should also care because you want to know what your rights are. You know, what are the pros and cons of being an employee? What are the pros and cons of being a contractor? And protect yourself from being taken advantage of as a contractor if you really should be an employee. So the rules are really here mostly to protect contractors from being taken advantage of. And, for my experience has shown that most of the time people aren't trying to break the rules. Employers aren't trying to break the rules. They're not trying to take advantage of people. A lot of the time the contractor wants to be a contractor. The company wants them to be a contractor. I do feel like the rules we're going to talk about today are pretty far-reaching and stifle the economy and discourage people from working together in these more casual environments. But these are the rules. So we need to do our best to adapt to them and try to minimize the risk as much as possible. So why would somebody want to work with a contractor? It's just a lot easier in a lot of ways, basically. So the contractors are going to be a lot cheaper. You don't have to create space for them in your office. You don't have to provide them equipment. There's less risk for the lawsuits that you get with an employee, which we'll talk a little bit more about. Just fewer legal hurdles in general. So, cheaper because you're not worrying about payroll taxes. You're not worrying about workers' comp, Social Security, unemployment. You don't have to worry about giving them benefits like you give to your other employees, like health insurance or paid vacation. And you're not on the hook for things like labor laws and wrongful termination and all of those things. So it's generally going to be a lot easier, a lot more flexible. You can just give them specific tasks, really short-term basis, and within their specialized area for a short period of time. You don't have to worry about firing them and the upfront cost of hiring. So it can be a really good thing to work with a contractor instead of an employee. So on the flip side, why would we want to be a contractor? Generally, you're going to have way more independence than as an employee. So you get to choose your own clients, you get to choose your projects, you get to choose what you focus on. You don't have bosses, really. You have clients, but not direct bosses generally. You're not going to have to deal with the bureaucracy of working at a big company, and you're basically beholden to no one. You're in charge of your job. So because of that, you have a lot more flexibility. You can make your own schedule. You can set your own rates. You can take time off when you want to, and you can work where you want generally. If you prefer to work from home or a co-working space or remotely, you can do that. So as long as it fits with the job you do. So often also contractors will get higher pay per hour or per project. And a lot of this is because the employer is not responsible for taxes and all of that. So that money shifts to the contractor, who is responsible for paying for your own expenses and taxes. But generally, you're going to get paid a little bit more because of that overhead shifts to you. And you just have more control over your income, because you, again, can choose your clients, choose your hours, choose your projects, and you're also choosing your expenses. So you're more in control of your expenses and income. So today we're talking about misclassification. What does that mean? So misclassification just means you're treating someone as a contractor, but under the law, they would actually be considered an employee. So what's the big deal if we misclassify somebody? So the first and big one is just if, for example, the government audits you and they find that your worker was actually an employee this whole time and not actually a contractor like you were treating them, you'll have to pay a bunch of back taxes for the work that they've done for you. So the size of the taxes you'd have to pay depends on a lot of factors, including how much you were paying them and how much they were working, but also whether you knew that they actually were probably an employee under the law. They want to know whether this was an intentional misclassification or an unintentional misclassification. So if you can show that there is a good faith belief that you really thought they were a contractor, the taxes you're still going to have to pay them, but it's going to be less than if it really, really was clear that this person was an employee. So generally, if you get audited for something like this, they'll look back 3 years. And so, 3 years of the part-time contractor who gets paid minimum wage is not going to be a big deal necessarily. But if it's 3 years of 5 full-time contractors, making 80 grand each, then that's going to maybe put you out of business. So you need to be really careful about this. In addition to the tax, and by the way, a lot of these taxes get paid by you, the employer, even if the contractor already paid all of those taxes. So this is bonus taxes for them. This is not necessarily just trying to recoup whatever taxes they didn't get. So it's definitely punitive. So there might be additional penalties on top of this, just as bonuses to punish you. So it can end up being very, very expensive. A lot of the time we also see additional audits. So, the EDD will audit you, and then suddenly you get an audit from the labor board at the same time, because they're definitely talking to each other. And so each agency is going to be getting money from you themselves separately. There's also just a risk of lawsuit from the worker. And like I said, we have seen sometimes the penalties be so big that people have had to close their business because they just couldn't afford all of the penalties. So it's a really big deal. So before I kind of jump into what the law is, I want all of you to understand kind of the two areas of law where that are implicated here. So you understand the difference between the two. So first of all, we've got administrative agencies like the EDD, the Labor Board, the IRS. So these agencies all have their own tests. And so the way that this usually is going to work is they are going to look into you for some reason, whether they're just doing an inquiry about a specific person or they're doing a general audit of all the contractors you've worked with. And then they are going to apply their own test. And each agency has its own test. So, but they're all pretty similar. So we can kind of group them all together. So all of the agencies are still using the same test that they've been using for the last few years. And the case we're going to be talking about didn't affect their test yet. So on the other hand, we've got what's called the common law. So common law is just law that was created by judges, basically. It's a way to create laws other than through statute, where a judge makes a decision in a case and that decision now becomes the law. So, so the way that this usually happens, these types of complaints, is usually the worker themselves will feel that they have been mistreated and feel that they have been misclassified. They will file a lawsuit, and then you go to court, and then the law that applies is this common law, the law that the judges have created in the past about issues like this. So the case we're going to be talking about, the Dynamex case, is a common law rule. The agencies still have the same tests as before, but they're all really related to each other. So that's why we kind of have to talk about both. So before this case came down a couple years ago, how did the law of independent contractor classification work? So first of all, again, we have the agencies. Each of them had their own tests, and the tests were all basically based on behavior and how much control the employer had over the worker. So again, these rules applied during that agency's own audit or complaint, inquiry. The consequences were per agency. So the EDD, for example, would audit you, and they would just collect the back taxes and penalties that they were owed. And one thing to know is that all of these tests assumed that this person was an employee first, and then you have to prove that they weren't. So, so one thing people always ask me is, why do these audits happen? Is there a way we can try to minimize the risk of being audited by these agencies? So there are two main ways I see this happen. One is because they have been tipped off by the worker somehow. And sometimes it's on purpose because they're disgruntled. Sometimes it's totally by accident because they've put you on like an unemployment insurance claim and they didn't realize that they shouldn't have listed you. So usually they'll look into that one individual person, and then that might escalate into a full-on audit for all of the rest of the workers you've worked with for the last 3 years. But also these agencies have the right to just do random audits for no reason. So a lot of the times they'll go after a particular industry or a particular geographic location, and just kind of audit that industry and that location. And so, one day just all of the yoga studios in Tahoe will get audited and letters in the mail. So you could do everything right and everybody can be happy, but these agencies still might just audit you for no reason, and they have the right to do so. So, and another thing is if they see that you are filing more 1099s than most people in your industry, that's another way that they might get tipped off, especially the IRS there. They're gonna look for things like that. So the common law world before this case came out, the main case that was governing at the time was called Borello. Same kind of test, just focused on the right to control, and we're going to talk more about that test. So again, this rule applied when someone sued generally for breaches of employment laws, and the consequences were decided by the court based on the damages that that were incurred in that particular case. So these are some of the many factors that were used when someone was deciding whether either the agency or the court was deciding whether the worker was a contractor or an employee. And this is probably half of the factors that they use. And so what they would do is do an analysis of all of the facts and all of these factors. And they're trying to decide whether generally, based on all of these facts, this person looked like a contractor or this person looked like an employee. So no single factor guaranteed that they would be just considered a contractor or an employee. They would look at all of them at the same time. So generally, all of these have to do with how much control the company has over the worker. And they also sometimes relatedly have to do with the contractor's ability to affect the money they make or lose by doing the work. So some examples here: what is the type of work that is being done by the worker? Is it a kind of work that's usually done by an employee? Or is it the kind of work that's usually done by a specialist without any supervision? Does it require any skill? And if so, kind of the more skill that's required, the more it's going to look like a contractor, because that's really what a contractor is supposed to be. The more skill they have, the higher the likelihood they're a contractor, because you're hiring someone for their expertise that you don't already have. We also are going to look at whether it's a distinct occupation, just meaning, are they doing something different from what you do? Tools, what tools do they need? Are you providing the tools or are they providing the tools? If they provide their own tools, that's going to look more like a contractor. If you're forcing them to use your tools or you're providing tools for them, that's going to look more like an employment relationship, because that's how you treat employees. Location is a similar one. Do they have to come work in your office on site, or are they able to work whenever and wherever they want to? That's going to look much more like a contractor. Payment is a big one. So are they getting paid per hour? Are they getting paid per project? Per hour is going to look more like an employee, because that's how employees get paid. Per project is going to look more like a contractor. Also, are you just cutting them a check every 2 weeks, the same time you're on payroll? Or is the contractor sending you an invoice at the end of the project and telling you how much you owe them? That's going to look much more like a contractor. So they do look at industry standard here. So even though generally an hourly worker is going to look more like an employee, people like lawyers or accountants generally charged by the hour. So that's not going to knock against you, but it's all very context-based. When and where, again, we talked about training. Also, if you are providing training to this worker, the more training you give them, the more it's going to look like an employee, because it's showing that you have control over the method of the work that they're doing, how they're doing the work. And so it's showing that you want them to perform this project in a particular way. So contractors are supposed to already know how to do the job. And that's why you hired them. But again, all of this goes back to the context and the rest of the factors. So if some training is required, then some training is required. But hopefully, they're already well versed in the thing you're hiring them to do. Whether or not the worker themselves has their own employees is going to be one. So usually employees have to perform the work themselves. You tell the employee, this is a project that you need to do. They can't just go give it to somebody else or hire an assistant to do the work for them. A contractor, depending again on the context, is not usually required to perform the work themselves. So they can hire helpers without even getting permission, with, depending on what's going on. Otherwise, it's suggesting that you have control over the work they're doing. If they have their own workers, it strongly suggests they're a contractor. Length and hours is another one. So the longer the project, the more it looks like they're an employee. So if it's an indefinite contract that lasts more than a year, or just doesn't have an end date and goes on until somebody chooses it to stop, that's going to look a lot more like an employee versus, we're hiring you until this project is done and it ends when the project is done. That's going to look a lot more like a contractor. Who's responsible for paying expenses? Is the work within the normal course of the business that you normally do? Is it something one of your employees would normally do? How can you end the relationship? An employee can quit or be fired at any time, at will, generally. Contractors, it's supposed to be harder to get rid of them. They're under a contract, so they're usually not really, you can't really fire them until the job is done. And if so, there's usually really specific reasons why you can. So they did something really wrong, or there's going to be reasons for termination, or they can quit only because you've done something wrong and breached the contract. So the harder it is to get out of that contract, the more it's going to look like a contractor. But if either party can just terminate at any time without notice, that's going to look more like an employee. And also, just what does everyone believe? Does everyone believe that they're a contractor or not? And is there a written agreement that shows that everyone agrees that this person is a contractor? So as you can see, all of these factors are very context-based and very based on what all the other factors are too. So tools, for example, sometimes I'm going to have to provide tools to the contractor. If somebody is a cybersecurity expert and they come into my office, I'm going to need to give them access. First of all, they're going to probably need to be in my office, and they're probably going to have to be provided with computers and access to our software and things like that. And so that's a required thing that needs to be done in order for them to do their job, versus a plumber comes to my office. So first of all, the context is, yeah, he needs to come to my office in order to do the job, so he can't do it remotely. But I'm not going to provide him with his own tools. He's going to provide his own tools. It'd be ridiculous if I said, come fix my sink, but here's a toolbox of the tools you have to use. You can't use your own. That doesn't make any sense. So that's kind of the general idea of how this test worked before this case came out. So again, all of the tests are based on the totality of the circumstances, which means they're just looking at all of the facts all at once as a whole, and not, no single factor is gonna make a huge difference. So even before this case came out, the agencies already were becoming pretty aggressive about misclassification issues, and we were seeing a lot of audits and things like that just from the agencies. So and all the agencies, again, will share information. So it was already a really big deal even before this case came out. This case just blew it even more wide open and made it even harder to classify someone as a contractor. So, why now? Why are they coming hard now, and why are they expanding the rule now? So part of it is just the economy is changing. We live in a freelance economy now. There are just more contractors now, I think, than there ever have been. Everybody's going out on their own as consultants and freelance creative industries and all of that. And then we just got the Ubers and the Lyfts and Postmates and all of that stuff that people are doing as contractors. And so there's just more of it. So the government obviously wants to protect people as much as possible, but also the government makes extra money if they find someone's been misclassified and they get all those back taxes, especially if the back taxes have already been paid by the contractor and now they're getting extra taxes on top. So as things get financially tighter, this is one way for them to make more money off of workers. Okay, so I don't see any questions in so far. If you have any questions in so far, for the people who've just been trickling in, feel free to send questions to me via the chat box. And also you should see a link to the slides in the chat box as well. So let me know if you don't see that, and I can resend it to everybody, but feel free to send questions as we go. So this case that you may have been hearing about, the Dynamex case. So, okay, we do have a question. Does the length of employment make any difference at all? So probably. So the length of employment is going to be one of the many factors that they're going to look at to determine whether they're an employee versus an independent contractor. So the longer the employment, the more likely it's going to look like an employee, because it's kind of this indefinite, we can kind of end it whenever we want to, probably, versus, get the project done and then you're done. Is going to look more like a contractor. So the longer it is, the more it's probably going to look like a contractor. But again, this is so context-based and so, interrelated with the other factors. So if, I have ongoing relationships with some of my clients, that doesn't necessarily mean that if I've been working with someone for 3 years ongoing, that I'm going to be an employee of them. But if you have someone who's maybe doing like some admin work or things like that for you, and you just have an open-ended contract with them, it's going to look more like an employee. So it does make a difference, but again, it's not going to probably make or break the analysis. All right, so the case that just came out, the Dynamex case. So you may have heard this test called the ABC test. It is a 3-factor test, and all 3 factors have to be satisfied to have that person be classified as a contractor. So, going back to our conversation about common law, this case really only applies to lawsuits for wage and hour breaches. So that's your minimum wage, your overtime, your breaks, things like that. So the consequences are going to be decided by the court, and they're going to be based on the damages incurred. So this case replaces the case we talked about earlier, Borello. So let's go through the 3 factors and talk about it. And again, keep in mind that we have a presumption that the person is an employee, and we have to satisfy all 3 of these to try to prove that the person is actually a contractor. So number 1, the worker must be free from the control and direction of the payor in connection with the performance of the work, both under contract and in fact. So basically what this factor does is wrap up that entire test we've already talked about into just 1 factor. So this 1 factor is looking at all of the context, and it's looking for whether the employer has control of the worker. So one thing to keep in mind here is that it is the right to control the worker, not whether you're actually controlling the worker. So even if you just kind of say, oh yeah, you can come and go whenever, and you can just, your job is just to open my mail. If you have the right to tell them how to do it, this factor is going to be a yes. It's gonna, you actually have control over them. So, and also this language, both under contract and in fact, same thing. It just means that even if your contract says that you don't have the right to control them, if you're actually controlling them, that's going to be what the court cares about. So again, we have our plumber example. They come to my office to fix my sink. I only have control over the outcome. I'm hiring them to come fix my sink. I can't tell them how to do it or what tools to use. But if there's an administrative assistant who's coming into my office and showing up at 9 o'clock every day, and she's on site or he's on site, and I tell him how to answer the phone and I tell him what work to do and when, then I clearly have control over this person. So a lot of examples come up here. So again, if we go back to our acupuncturist or yoga studio model, where the owner owns the space and they act like these people are just contractors because, oh, you're just renting the space from me, or you're renting the chair. But really you're telling them, okay, you're giving a class 3 days a week, Monday, Wednesday, Friday at 10 o'clock. And the studio is going to take the payment and we'll just pass along payment to you based on how many people come to your class. That kind of control is going to be enough control to show that your yoga teachers are actually employees and not contractors, even if you have a contract that says otherwise. So we also had another one that was a company that provided nanny services, and they had all of their nannies classified as contractors, but they had a monthly training that everybody was basically required to come to. And they said they're not required, but really they actually were required. And so that's going to be a factor that's going to look like they're employees and not contractors. So, and feel free to send over questions about factor A, because we're about to move on to factor B. So factor B used to be one of the many factors from before, but now it's its own. So the worker must perform work that is outside the usual course of the employer's business. So basically, they want to make sure that the work the contractor is doing is outside of your normal day-to-day operations. So it's not a key part of the services you normally provide. So again, the plumber coming into my law firm is clearly not doing stuff in my normal day-to-day operations, but the admin person probably is, because I have to open my mail, I have to get my phone answered in order to do my job. So this is really trying to restrict the contractor role to the really kind of traditional contractor role. So plumbers, electricians, lawyers, accountants, all of those things. But the question here is, what services are you actually providing people? There's actually a lot of ambiguity built into this question. And so, some examples of this ambiguity, somebody has an ad agency and they're creating, marketing materials for people. If they hire a contractor who is a copywriter, does that copywriting count as, the usual course of their business? It might depend on how they run the business and what the other person is doing. Also, concierge services like, again, this nanny service or a home, in-home care company. The question is, are you providing nanny services or are you providing a concierge service that is linking nannies with families? And that's kind of the main question of that Uber lawsuit that you've probably heard about. The Uber drivers are saying, we're clearly employees because you are in the business of providing drivers for people who need drivers. And Uber says, no, we're a tech business that is in the business of providing a digital platform that allows the drivers and the riders to find each other. So this becomes a key question. So in our nanny example, we might have to reframe the entire website, the entire business model to say, so the website shouldn't say we provide nannies to you. The website to say we are a concierge service that links nannies with families, and it can change your model here. So you have to, it's a question you have to ask yourself: what is my business, and what counts as within my business and what outside of my business? So factor C. The worker must be customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed by the worker for the payor. So basically, the government just wants your contractor to have their own business. So we're going to look for things like, do they have other clients? Are they working full-time for you? Do they have specialized training? Do they have their own website? Again, they really, really want everybody to have these traditional contractor roles, your plumbers and your lawyers. And they want, they want this person to have their own thing going on. So we have a question from an architect, I'm assuming, who says, can you see a scenario where a drafter can be considered outside the usual course of business for an architect? So I would need to know, more of the details of the industry in general and also of your particular firm. But I think a lot of that answer to that question might come down to these other factors. What does the drafter do? Do they have other clients? Are they, do they have a lot of experience? How much control do you have over them? There's also, some weight in just industry standard here. So it's really hard to give kind of straightforward answers for all of these kind of what if scenarios, because they're so highly dependent on your particular firm, how you run your business, who that person is, and what exactly they're doing for you. So yeah, we have a comment from someone in the financial industry that says, this is the rule that's extremely restrictive. If I provide bookkeeping services to my clients and hire an offsite bookkeeper to do the work at her own time on her own computer, that person would still be considered an employee. Real estate and insurance agents who have always been considered independent contractors would still be considered employees. How strictly do you think this is going to be enforced? So that's an open question that I was going to talk about at the end, is really, we don't know yet. This is a new enough rule that we haven't seen it be applied too much. And so we'll talk about kind of what I'm seeing at the end and address that a little bit more. But the question really is, we don't know quite yet, which is unfortunate. So, all right, so factor C here, again, the court wants the contractor to have their own business, basically. So again, there's a lot of ambiguity built in to this factor, which is really frustrating. So, what if you hire someone on Fiverr to draft some marketing materials for you, or a consultant who is says they have their own business, but they're really only working with you. And so there's a lot of ambiguity about what counts as them basically having their own business, how much weight the different factors have here. So another example I've used before is just paralegals in law firms. You can have the paralegal who comes into your office and you're telling them what to do and how to do it, and that's going to look like an employee. But there are also paralegals out there who have their own businesses and have their own systems and procedures. They don't come into your office. You just say, "Can I have one set of bylaws, please?" And they send over their own set of bylaws with the information you provided them. So they might have 20 different clients at a time. And they have total control over the work that they're doing and the work product, and you only are asking them for a result. So that probably can look like a consultant. So it's all very, very context-based. Okay, so what's happening now? So far, all of the agencies are still using their own tests, and it seems like they're applying them in the same way that they did before this Dynamex case came out. Basically, everybody hates this rule. Employers hate this rule because it's harder to work with contractors, and contractors hate this rule too because most contractors want to stay contractors. So there's a lot of pressure and a lot of lobbying going on and a lot of just public pressure to loosen up this rule because nobody really likes it, except for, the state likes it. And of course, the people who are being taken advantage of do like to have this protection here. So, like the question that just came in, there are tons of questions remaining about different fact patterns, what the different agencies are going to do, how these rules are going to be applied. There's a lot of just gray area about things like, what does usual course of business mean? What does independently established trade mean? There's a big question pending right now about whether this Dynamex case is going to be retroactive. So that means if they decide it's retroactive, you could be held liable for misclassification before this was even the rule. They can retroactively apply this and say the contractors you worked with 5 years ago, you didn't meet the standards of this test, which is crazy. And so a court actually decided, yes, that it was retroactive, and now that decision's on hold, and the California Supreme Court is deciding whether they want to make that decision. So we'll find out in the next couple of months whether they're going to take the case. But in the meantime, we don't know questions like this, and it's really difficult to give people advice and for you to know what to do. So we just kind of have to wait and see, unfortunately, for a lot of this. So with all that in mind, I want to spend the rest of the time talking about how to minimize the risk. These laws are really overreaching and very hard to navigate. So what can you do as an employer or as a contractor to at least try to minimize the risk of misclassification as much as possible? So, and again, remember, like we said before, a lot of the penalties are based on whether it was an intentional or an unintentional classification. So even if we do everything we can to classify someone as a contractor and the government says otherwise, we at least have a really good argument that it was unintentional. We really tried, and so at least the penalties will be a little bit lower that way, and you have an argument to make. So number one option is just to turn them into employees. So this is really the only option that's going to remove the risk of misclassification, of course, because they're no longer contractors. But this is not really an option for a lot of people because employees are really expensive. So you know, if you hire everybody, suddenly you have to live up to all of these wage and hour laws, the minimum wage and the breaks and the overtime. You also have all these other rules you need to comply with. You need to be really careful about discrimination, harassment, retaliation laws. You're going to want to have things like handbooks and policies, and there's all these other laws that you have to comply with that wouldn't apply otherwise. You're going to have to pay employment taxes for them, which get really expensive, and you're going to have to get workers' comp and unemployment for them, and there's just higher risk in general. And then you're just, you know, cost of running payroll, cost of creating a handbook, whatever, all of those kind of ancillary costs as well. So, I think this is often a good option for high risk industries. If we've seen an industry as being audited a lot, like our yoga studios or our wellness studios, or it's just really obvious that this person is actually an employee or admin, or, you know, someone who's doing actual work for you that an employee would otherwise do, my advice usually would be, if you can, turn them into employees, because the risk otherwise is just going to be too high. But if this really isn't an option, or you legitimately feel like you're in enough of a gray area that they could be considered contractors, we can keep them as contractors. So if you are going to keep them as contractors, we at least need to take the time to weigh as many of those factors we talked about as possible in favor of looking like a contractor instead of like an employee. So, this will end up in the long run being less costly than having employees, but you have to know that there's going to be a permanent ongoing risk as long as you're working with contractors. And you have to be willing to take that risk. So, some people are willing to do this because they just literally would go out of business if they had to hire people as employees. If you're willing to take the risk, then you can take the risk, but know that there is a risk. Unless obviously you're hiring your lawyer or your plumber or somebody who's obviously really a contractor. So what do we do to minimize our risk if we're keeping them as contractors? Number one, ask a ton of questions. So ask questions of yourself, ask questions of your potential contractors. So what type of work are they doing? Is it the type of work that's key to your business? Do they have their own company? Are they working for other clients at the same time? Where do they work? Are they providing the tools, or do you have to provide the tools? What equipment is required? How much oversight do they need? How much training do they need? Do they have their own insurance? Because they really should. How is billing going to happen? Are they going to invoice you, or are you just expected to cut them a check? Are you paying them by the hour, or are you paying them per project? Look for things like if they have their own website, if they have their own employees. Is this a job that requires experience and expertise, or is this something that's kind of anyone can just step in and do? Do they have other clients? Do they have an office space of their own? So dig in, and with the context of all of these factors, ask yourself questions about how each of these things looks. Does it look more like a contractor, or does it look like an employee? Number two, you want to get documentation as much as possible to prove the fact that these factors look like contractors and not employees. So you definitely want to have a written contract with all of your contractors, especially if you're in a gray area. So this contract will sort of codify the relationship and say, you, contractor, are responsible for your tools and your expenses, and we are not paying for your taxes, and we're not paying for your workers' comp, and you have to have your own insurance, and you're a contractor, and everybody agrees you're a contractor. So again, this is not going to guarantee classification as a contractor, but it's going to really help. You're also going to want things like business cards with their name on it, showing their business. You're going to want to see their website. You're going to want to see proof of insurance, that they have insurance and that they have workers' comp on their own employees. If they're driving for work, you're going to want to see that they have auto insurance that covers the work they're doing. You're going to want to see business licenses, leases to prove they have a space, employee info, things like that. And so, the documents you're going to ask for are going to be different based on the job that they're doing for you. You're not going to ask your plumber for the lease to their building, but you at least want to have enough proof based on the context of the relationship that they are a contractor and they have their own business. So copies of their advertising, things like that, and then keep copies of the invoices that they are sending you. And sometimes you can even ask for just blank invoices before you work with them to prove that they have their own invoicing system. So the next one here is obviously just don't treat them like you treat your employees. So don't use the same contract with them you use with your employees. Don't give them a handbook. Don't invite them to your employee functions. Don't call them an employee. One thing I see a lot is you go on the website, let's say a yoga studio again, and all the teachers are contractors, but it'll say, meet our team, and then have pictures of all of the contractor teachers. That looks like employment. So you don't supervise them like you supervise your employees. You don't let them work at your office or give them tools unless it's absolutely necessary to the job they're doing for you. You don't tell them when to work. You don't give them benefits, unemployment, workers' comp. You don't give them business cards. You don't give them a uniform. You don't give them an email address. That's another one we see a lot. And you don't pay them the same way as you pay your employees. You're making sure they're paying their own taxes, their own insurance, their own workers' comp if they need it. So another way to do this is also to just satisfy the wage and hour laws anyway. So they can't bring a Dynamex claim against you for the ABC test if there's no breach, even if they were an employee. So, you know, what would the minimum wage be if they were an employee? What would their break requirements be? What would their overtime be? You know, we see this a lot where you are paying a contractor per project, and then if you separate out all the hours that they've done for you, they would actually be making less than minimum wage. So in situations like that, just make sure that the work that they're doing for you actually does end up being more than minimum wage or covers any overtime you would have had to pay them. You know, make sure that if they're on site for some reason, that they have breaks and all of those things that you would otherwise be giving them. Because then they don't have the right to bring a claim, even if they had been classified as an employee. So, and it's also just good practice, you know, let's make sure everybody's getting paid what they deserve. Everyone should be getting paid more than minimum wage, even if they're a contractor. So finally, these are all issues that are really helpful to get, you know, professional legal help with. So there are lots of things a lawyer can help you do. So step one is just consulting on whether this person should be a contractor or should be an employee. Someone who is very familiar with these rules can sit down with you and go through every single contractor you're working with and say, how well do these people fit into the test? And what's going on in your business, and what's your comfort with risk? So, you know, we can help give advice about whether you should keep your people as contractors or whether some or all of them should be moved over to be employees instead to minimize your risk as much as possible. So the next one is we can help, if you're going to keep your contractors as contractors, we can help minimize the risk of misclassification. So again, we can see how much they're getting paid. We can see how you're treating them. We can make sure that every single one of those factors looks as much like a contractor as possible. So make sure you're not, you know, giving them email addresses and telling them when and where to work and how to do the work, and really help you craft the relationship. So you're really just hiring them to do the job, and you're telling them what outcome you want, and they do the rest. So a key part of this is the next one, is just write contracts. So we write contracts both from the perspective of the employer working with the contractor and for the contractor. You know, somebody who's like a freelance wedding photographer or something in the creative industry, web developers, people who are working as contractors for other people, because the terms are going to be really different depending on what side you're on. So contracts are, again, a really important factor in what the classification looks like. They're not a guarantee, but they're a really strong factor. And they're also going to minimize just the risk of conflict between the two parties, because everybody agrees up front, this person's a contractor, this is what you're responsible for, this is what I'm responsible for, and it's going to minimize the risk. And so other ways we can minimize risk here is by being really clear about what the job actually is and what the standards are for doing that job, because we see that happen a lot where you know, there's just, once you start doing the job, turns out there's confusion about what the job actually was. So we're going to hopefully prevent lawsuits that way as well, and prevent conflict in general. So the next thing here is, if you do decide to hire people as employees, there's a lot you need to do to make sure you're complying with all of the laws. So there's just a huge amount of laws that apply to you once you start having employees. So you've got federal, state, county and city laws governing employees, and all of them overlap, and it can get very confusing. So contracts with employees, if you need a handbook that's going to minimize lawsuits from employees, just any help with onboarding and setting up your system for hiring employees for the first time, and just making sure that the employer, you're not making mistakes. So, and finally, we have helped people with audits before. We prefer not to do that because we prefer to try and minimize the risk of audit and try to not get you audited to begin with. But if you do get hit with an audit, it is helpful to have someone help you to make sure that you have someone who knows the law on your side and try to minimize the damage, because it can be really easy to upset an agency, and then they will tip off another agency, and then you've got all of them coming at you at the same time. So that is the stuff that lawyers can help with. So we do have some time here for questions. I just got in one. So another architect question here. Our architecture firm hires an employee for an agreed upon short-term contract to do drafting or design work for a specific project. Can we agree on the length of employment when we hire them, or because they're an employee and not an independent contractor, does this mean we have to terminate their contract when done, at which point they can apply for unemployment insurance? So employment in California does not have to be at will. At will is just the default. So you can have terms on employment as well. It's just going to require a contract. So if anything other than at will is going on, you just need to have a contract with the employee that says, we're just hiring you to do this project, and it ends on this date or when the project is done. You're still able to do short-term projects with an employee instead of a contractor. Yeah, so that I think answers that question. Who else has questions? Send them on over. And here in the meantime, if anybody's typing up questions, is our contact information. So, again, a lot of these questions are hard to answer in a straightforward way, at least, because they're very fact-based and very contextual. So the answer in short form is always going to be, it depends on what else is going on. But if you need to do a more detailed analysis, or you just have follow-up questions, we are happy to do that with you. And so that's my contact information there. Another really good way to get in touch with us if you want to have a longer conversation about your particular situation. The link here, abl.as.me/intake, is a way to just automatically set up a meeting with our intake specialist, Mary Lou, who's also very well-versed in these issues, and she can help figure out if it's something we can help you with and give you some guidance. So I'm not seeing any more questions coming in. You can feel free to follow up with me over email or book an appointment, and we can talk about your individual situation more. So we will be posting this online. Also, if you need if you want to look back in, and everybody should have the slides there in the chat link. Otherwise, you can email us, and we will email the slides to you. Okay, we do have one more question that just came in. What about an employee that you would hire multiple times for projects? Do you need a new contract every time? So it depends, like I said, on what's going on. So, this is really, really common in certain industries to just keep doing work with the same client or the same contractor over and over and over again. So, best practice, I'm the lawyer, so the best practice is going to be have a new contract every time, because that contract is going to be specific for that particular project, and you want to be able to be really clear every single time what the scope of the project is and all of that. But we know that this is actually not happening. Nobody wants to enter into a new contract every single time you work with somebody or have a different client or something. So one thing that you can do, first of all, if it's an employee, you can just have it be at will. You can just, have them be an employee when you need them and don't when you don't. And so you don't need a contract when you have an employee. But also if we're talking about contractors, sometimes we'll put language in a contractor agreement if we're working with contractors, or as a contractor, that just says every future project that we do for you, client, will be governed by this same contract terms, unless we both agree in writing. So So, you know, it's not as good as having a brand new contract every single time, but at least we have some language to go back to look at if there is a conflict. And so then in that case, we at least want in writing the terms of the new project. So in that count, it can be an email or a work order, a statement of work, something like that would count, that just says, this is what we're doing and this is what it's going to cost. And these are, you know, the obligations of each party for this project. So another question came in. It seems that even if all other pieces are taken care of, if someone is doing the same work as I, they'd be an employee, or is there flexibility there? So under the Dynamex test, if they're doing work that you would otherwise be doing yourself, that's just one factor, and it just takes one factor of the ABC test. So yeah, unfortunately, I think under the Dynamex test, that means that they would be considered an employee, which I agree is overreaching and frustrating. So again, though, I think in reality, we're going to look at the rest of the circumstances going on. So kind of going back to our paralegal example, if they have their own business, if you're not telling them what to do and how to do it, you might have more wiggle room to at least defend yourself. But it's gonna depend. But yeah, if there's one factor that's not satisfied of the three under the Dynamex test, that's gonna be an employee under the Dynamex test. So another question came in. I have 2 contracts to do work for 2 different architectural firms. One requires a new agreement every 6 months. The other one just at start of contract, which was 16 months ago. Is there any risk to me / my company for not being, or their company, I think, for not being consistent with my contracts as a contractor? No, because I think, you know, different projects are going to be different depending on what's going on. So it's fine to have different terms for different contractors, or as a contractor, different terms for different clients. But in general, the one that's going to be renewed every 6 months is going to look better for contracting than the one that you did 16 months ago that's kind of indefinite. Just it's better in general to have it be you know, shorter term that gets renewed or is per project than indefinite. But as far as having different terms per client or per contractor is generally going to be fine. Another question is that Dynamex test going to be the norm? It's obviously the most restrictive, or is this part of what we don't know yet? So right now, the Dynamex test is the test for wage and hour lawsuits. So the agencies still have their own tests. So it is the norm now for lawsuits. I'm hoping that it's going to be cut down over time, because like I said, nobody likes it. It seems like a bad rule, and I think it's bad for the economy. So we just have to wait and see what it's going to look like, and we have to wait and see if the agencies are going to expand their tests. So far, they have not, but their tests are already really open. Another architect here, if 2 architects join forces to work on a project and the billing goes through just one, is the other an employee? That's a good question. Again, it depends. Probably not. It depends on the relationship between and who's doing what. So again, that's something I'd have to really look into the facts of, the relationship between the 3 parties, the client and the 2 architectural firms. But if everybody's doing different things, not necessarily, you might be a subcontractor. The fact that you're both, I'm assuming both have your own firms, is going to be really helpful in that scenario, because you're not just an architect doing work in someone else's firm. So again, you know, the fact-specific ones are hard to answer without any other context, but it's probably, you probably can make it work depending on what else is going on. All right, I don't see any other questions coming in. So that is our contact information, and thank you everybody for participating. Thanks for people who are sending positive feedback. I really appreciate that. I'm glad it's been helpful. Thank you so much for taking the time. I know it's you know, an hour in the middle of the day and you could be doing other things. So I'm glad it was helpful. Please feel free to reach out with questions, and if you need the slides or you have, you know, other things we can help you with. So the question about the link to the slide deck, it should be at the top of the chat box here. I can actually resend it. I'll resend it right now in the chat box. It should pop up really quick. 1 second. All right, so it should be there. Oops, I just sent it to only one of you. I'll send it to everybody again. Okay. Okay, here we go. And if you're watching on YouTube later also, we can send the slides over email if you email us. So it should be there in the chat box, all of the slides. So hopefully those are helpful as well. And thank you everybody so much for taking the time to participate. And yeah, best of luck to everybody. And I hope to communicate with many of you again in the future. So I hope everybody has a wonderful day. Thank you so much.